Well, hello, everyone. Thank you for tuning in today. Welcome to It's Time for More Injury Funding, the podcast for all who want to learn about legal funding and its significance in personal injury, workers' compensation, civil litigation, medical malpractice, and many other types of law practice domains. I'm your host, Laura, founder and CEO of More Injury Funding, the legal funding counselors with passion for law, medicine, legal funding, and heart for all suffering individuals. More Injury Funding is a sponsor, member, associate, or business partner of this podcast, Georgia Trial Lawyers Association, Academy of Truck Accident Attorneys, Sandy Springs Bar Association, Georgia Association of Paralegals, Atlanta Legal Aid Society, State Bar of Georgia, St. Andrew Rowing Club, and Georgia Hispanic Chamber of Commerce. In today's episode, I have a very special guest, attorney Matt Nakajima, a sought-after trial attorney focusing his practice on wrongful death and catastrophic injury cases with Rittgers Rittgers and Nakajima based in the state of Ohio. Matt's passion and dedication to clients drive his results. In the last 8 years, he has obtained over 50 million in verdicts, judgments, and settlements on behalf of his clients. A few years back, in 2022 alone, Matt has successfully resolved cases for 7 million, a couple cases for 3 million, a few for 2 million, and numerous 1 million policy limit settlements. And at the end of our episode, I have a fun pop-up question, so stay tuned in. Welcome to It's Time for More Injury Funding podcast, Matt.
Hi, Laura. Thank you for having me. I appreciate it.
You do not shy away from difficult cases and are known for obtaining extraordinary results under the most challenging circumstances. Tell us about that and give us a few recent case examples.
Good question. I'll tell you, it started out not by choice. When you're a young lawyer starting out and you want to get trial practice, a lot of the cases are difficult cases. They're cases that other lawyers turn down. So for the longest time, to build my trial practice, I would go around to other lawyers in my community and I would ask them, do you have any cases that need to go get tried? Do you have any difficult cases that aren't settling that maybe you just don't want to keep anymore or you want to co-counsel with me on? And that is how I got the opportunity to start developing a practice of going to try cases. And it kind of snowballed into being somebody who other people would come to start trying their difficult cases. It didn't start out where I was winning them all the time. You know, it's trial by error and it's getting the reps and the experience in the courtroom over and over again. But eventually I found my footing and I started to have some success. In terms of, difficult and challenging cases, we have plenty of them. Some of them go to trial, some of them settle outside of court. One in particular, it's not a one where we got some big verdict. It's one, though, that went all the way up to the Ohio Supreme Court and back to the trial court. And it took over 9 years to resolve. And it was a catastrophic brain injury, and we just kept sticking with it. We came into the case after it got back from the Ohio Supreme Court. We relitigated it, and we ultimately were able to recover enough money to take care of this young man for life, a young man who was catastrophically injured when he was just 17. That one stands out to me as just a case about perseverance and continuing to fight in spite of very difficult odds. I think a lot of people, when they ask me to speak or want to know about specific cases, a lot of them ask about the casino case against Jack's Casino. That's when I tried with my partner, Charlie Rittgers, and not a young woman, an elderly woman who come to the casino, and she slips and falls on a wet floor sign. And that garnered a lot of attention because it's like, hey, you fell on something that is supposed to signify danger. But what made that case unique is that upon getting the video, the reason that she didn't see it is because it was broken into, it was translucent and matched the color with the floor. And the only reason it was on the floor is a casino employee walked right by it, saw it broken up on the floor, and didn't pick it up about 10 seconds before my client fell. And in that case, we had a settlement offer at the time of $20,000. My client had suffered a devastating fracture to her kneecap that resulted in a very serious surgery that impacted her mobility. And we couldn't say yes to the $20,000 offer, and we went to try the case, and we got a $3 million verdict. And that is something that really resonates with me because so many people said it wasn't possible to get justice for her. So many people who did not know the facts of the case thought this is a frivolous lawsuit. This shouldn't be brought. And to be able to obtain that kind of justice and kind of open up eyes to other people in my community about what the value of someone's human suffering can be, if you're just not afraid to ask, really was a beacon that stands out in my career.
These are amazing stories, Matt. As a result of your track record of success in the courtroom, you are often asked to speak to trial lawyer organizations across the country on trial advocacy, litigation, and injury law. You are highly respected by your peers, and you have been a recipient of the prestigious Super Lawyer and/or Rising Star Awards by Super Lawyers every year since 2013. What does it take for a trial lawyer to receive all these recognitions?
That's a good question. I don't have a firm answer for it. I'm just very blessed and honored to get asked to speak to other trial lawyer organizations. I never purchased those awards. I don't hang them on my wall. The awards themselves don't hold a lot of value to me, but I do appreciate when I get offered one. But honestly, the respect from my peers, by other trial lawyers asking me to speak, to work on their cases, to focus group cases with them, to explain how we go about developing case themes and cross-examinations of critical witnesses. That's one thing I'm really passionate about, because there was a time when I would go to seminars and I would see people standing on that podium wishing I was the one speaking. What's it going to be like to be where they are? And now to be in that position, I just feel very blessed and humbled that so many other lawyers are willing to spend their hard-earned time and money listening to me.
Just beautiful. What are some key strategies for developing trial skills as a lawyer?
Another really good question. I get often asked that same question by a lot of young lawyers. And the real key is just to go try these cases. I know it's easier said than done. We all have fear. We all have self-doubt. We all have clients who rely on us, though, to not take the easy way out. And so many times lawyers are afraid to go try these cases when they should. And you just have to have that courage, that willingness to go try the case. And if you lose, that's okay. You just have to pick yourself up and do it again. And that's the way I develop my trial practice. Again, going around asking people to try their cases. And you don't start out with that $1 million case, or that case where someone's catastrophically injured by a tractor trailer and there's tens of millions in insurance coverage. You cut your teeth by trying those no visible property damage cases, those rear end collisions that only had chiropractic treatment. But you get those reps in and you develop that comfort level. That's one thing that I think will help people try more cases. Another thing that they should be doing is, whether speaking on a podcast like this, going to a Toastmasters, but putting themselves in positions where they're speaking publicly, where they're actively having to be on their feet, thinking quickly, and becoming more comfortable talking to different types of folks. And that will help you feel more comfortable and help you develop your trial skills.
Wonderful. What recommendations, Matt, would you give to practitioners to effectively prepare for a trial to improve their chances of success?
Focus groups. I cannot stress that enough. You need to start focus grouping your cases. So many lawyers, whether it's a lack of funding, they don't have the money, they say they don't have the time, they don't want to focus group the case. That, to me, is a recipe for disaster. You might get lucky and do a good job at trial and win, but you're going to be much, much better if you work on that craft, if you focus group that case, if you get feedback from prospective mock jurors about whether the arguments you're making, the facts you're introducing, are resonating with them. So many times we go into focus groups thinking what's really, really important, or is the key to winning the case, turns out not to be. It's so many of the little things that we don't think about. So I'd highly recommend that if you have some case that you think is a high value case, that you focus group it early before you even file a lawsuit, so that you can figure out what issues are resonating with people who aren't lawyers, what facts they think are important. And then after you gather that information and you're in litigation, then you refocus group the case with a strong defense theme, a strong plaintiff theme to figure out what really is or is not going to work at trial. And if you do it with a larger data set, so sometimes we'll do a 400 or 500 person focus group with, say, John Campbell and Alicia Campbell at Empirical Jury, we can start getting a better idea of what kind of jurors we're looking for, political leanings, male, female, work history, but also how jurors at a macro level are valuing our specific case.
What are some common pitfalls to avoid during trial proceedings?
Common pitfalls. I would tell you that lack of preparation is what I think is the singular biggest reason why lawyers are not winning trials. I don't really look at any cases being unwinnable. There are very, very difficult cases. There are cases that require a lot more work than others, but you have to take the time and the effort, and you have to do everything you can to try to win. I also wouldn't skimp on putting up case expenses. If you need animations, if you need demonstratives in the form of exemplar brains or body parts that have been injured in a crash, you need to go get them. Because in this day and age, jurors want to be entertained. They are used to TV. They are used to seeing demonstratives, visuals. And you need to make sure that you are presenting your case in a package in which the jurors will accept it and appreciate it. Another big issue that I see people doing is they're not themselves. I tell young lawyers all the time, you don't have to be the most polished lawyer in the world. You don't have to have a bunch of gray hair. You don't always have to get the question just right, but you need to be yourself. There's value in authenticity. There's value in being genuine. And when you take time to speak to those jurors or to cross-examine that witness, sometimes it's best just to put those notes down and listen, truly listen, make eye contact with them, make that connection with them, and listen to what they're saying and respond accordingly. Not just read the next question that you have on that piece of paper or some pre-written script for opening or closing.
Important do you believe is courtroom demeanor and presentation influencing the outcome of a trial?
Oh, 100%. 100%. I think in many respects, jury trials are about likability and credibility. And if you lose either one of those, you could have the best case. But if the jurors don't find the lawyer credible or likable, or they don't find your client credible or likable, even if they find for you, which is going to be much more difficult, they're not going to feel like they want to be your champion, like they want to be your client's champion, like they want to give some verdict in favor of them. And so how you present yourself, your demeanor, your appearance, the way you treat other people, you always got to remember someone's watching. I tell my clients and I tell my associates when we go try this case and my co-counsel, you need to assume someone is watching you anytime you're anywhere near that courthouse. You are who you are when no one else is looking. And sometimes jurors see someone being rude to somebody in the parking lot or not holding a door for them at the elevator. All those little things come into play, and it changes the way people perceive you.
Absolutely. What role, we touched on this briefly, but what role do mock trials and simulations play in honing trial skills?
They are critical. They are critical. And we touched on that previously, but in addition to doing mock trials and doing focus groups, you also need to practice what you're doing. For a long time, I used to have these life-size poster boards in my basement, and I would practice speaking to jurors. I would practice giving an opening statement or questioning jurors about their feelings and beliefs. And I would work on simple things like eye contact, like hand movement, like my facial expressions. Sometimes I found out that I make funny faces. I don't mean to, I just do. But if you practice your presentation and your demeanor before you get to court on a regular basis, you can make the unconscious conscious so that you can have what's called emotional congruence. Your body language is matching your words. Your facial expressions are matching your words. When you're using me statements, your hands going here and not towards the person you're speaking to. All these little things, they add up to increase your credibility, your likability, and your persuasion skills.
What advice would you give to lawyers, especially younger lawyers, to effectively engage with jurors and build rapport during trial?
Yeah, another great question. I think it comes back to being yourself. And I know that that is easier said than done because so many young lawyers say, I don't know how to act. I don't know what questions to ask. So they're emulating somebody else. They're using someone else's words because they watched it on TV or they went to a seminar and heard somebody speak. And that's great. There's nothing wrong with borrowing from other people, but it needs to make sure, you need to make sure it fits you. And being authentic, being credible can often be much more persuasive than anything else you can do, because it's not what you say at trial as much as how you say it.
What are some effective techniques for cross-examining witnesses during trial? And I know you've done quite a few of those. What techniques do you use that really make sense?
It really depends on the witness. Sometimes you need to be very delicate. Sometimes it could be someone on the other side that you have to be very careful of what you say. Maybe you could come off as too aggressive. Let's break it down, for example, like an expert witness. So many lawyers want to get into a shouting match or a pissing match with the other expert, trying to score points. Sometimes you don't want to go down that road. You just don't. Because if it's a medical issue, if it's a defective product issue, that expert's going to know more than you. So you need to make sure you stay in your lane. You need to keep your questions tight. Okay. You need to ask short, one fact per sentence questions. Not all the time, but that's a good practice. Okay. You also need to make sure that you're not asking questions you don't know the answer to. Okay. If you leave an open-ended question out there, sometimes an expert will completely run with it. So let me give you a prime example. Sometimes I will do an agreement cross, okay, with an expert, and I will simply ask them to agree with me on certain facts that I know they must. And what I'm doing is I'm advancing my case, and I'm not putting myself in a position where that expert's going to score points against me. Another type of strategy you can use is, there's a difference between a fact and an opinion. Doctor, it's a fact that my client was injured on June 10th, 2012. It's a fact that they suffered a comminuted tibia and fibula fracture. It's a fact that required emergency surgery. It's a fact that impacted their ability to walk. It's a fact that they told their treating doctors they never got better after all that physical therapy, after all those surgeries. But doctor, it's your opinion without seeing my client, he's fully recovered. That's a quick way to differentiate your facts versus their opinion and kind of painting them into a corner.
Could you point to some resources or training programs available for lawyers looking to enhance their trial skills?
Absolutely. Again, this is not a substitute for practice. It's not a substitute for developing your own trial skills, but there are so many great resources out there. If you don't have a lot of money, you can go to the local law school or your public library. I would read Rules of the Road by Rick Friedman, Polarizing the Case by Rick Friedman. I would also read Keith Mitnick's books on Don't Eat the Bruises and Deeper Cuts. Keith Mitnick also has a podcast on Apple that you can listen to, and he's giving real-world trial techniques and trial strategies. Lastly, if you're not trying cases, go watch them. Make sure that you are. I would call the courthouses and ask these clerks, anybody have any civil trials that are coming up? And if it was a good lawyer, I'd always try to make time to go watch. If you don't have a lot of people trying cases in your neck of the woods, get on CVN, Courtroom Viewing Network, and you can watch trials from all over the country. And lastly, there are trial programs such as your local plaintiff's bar in the state that you're in. Where I practice, we have the Ohio Association of Justice and the Kentucky Justice Association. Go to those conferences, get involved on the listserv, connect with people, take advantage of the resources they provide. And finally, you have a Trial Lawyer University, which is a great resource, and Trial School. And if you're a plaintiff only practitioner, then and you get verified, then you have access to their database of all the presentations they've ever done.
And before last question, before I let you go, Matt, what are some effective strategies for dealing with difficult judges or opposing counsel during trial?
Well, we can start with the judge first. I think we've all, if you try enough cases, you're always going to have a judge that doesn't always see things from the same prism in which you view the world. And one way that I've effectively dealt with that, when I've had judges that don't want to hear me making any more objections, don't want me to keep making arguments after they've already ruled on something. If I absolutely have to get my point across or get it on the record, I'll just simply tell that to the judge. Like, Your Honor, I have tremendous respect for you. And in fact, you actually kind of scare me because I don't want to upset you. But what kind of lawyer would I be if I did not have the nerve to make sure that I put on the record what I had to put on here to protect my client? So if you'll just give me a brief couple of minutes so I can, preserve the record for appeal, I'd appreciate that, because I have to do it for my client. And that's the way I would deal with the judge. Be very, very respectful. If I am being critical of something that he's ruled on, I don't look at him directly. I might speak away from him just to show a sign of deference. When dealing with opposing counsel, the main thing that you'll get are people who do last-minute introductions of witnesses that they never previously identified, slipping in last-minute records that they never identified, and in particular, trying to obstruct your case by constantly making objections. One way is to make sure that you approach the court with hard deadlines. You want to make sure you get out in front of it, filing motions to the court saying, hey, judge, this lawyer has a reputation for making these types of arguments, or for sandbagging us with last-minute witnesses or evidence. We need a hard deadline, and we need some guidance from the court about what parties can and can't do and how counsel is supposed to behave. That's one way to do it, by getting motions in limine to prevent bad conduct. But another, you just have to deal with it through experience. When you get people that are constantly making objections, constantly trying to throw off your flow, it's important that you don't let it impact the case that you're bringing. You need to stay in control. Don't let your emotions get the best of you so that someone else can throw you off of your game. Because if they see that, they're only going to keep doing it more.
This is great. So great. I hope that this episode of both Mastering the Art of Trial Practice and Strategies for Success was informative and educational. And as promised, Matt, I have one last pop-up question for you. Ready?
Okay, let's go.
What is your favorite way to unwind and relax after a long day or long week?
I have two daughters. I like to spend time with them. In particular, we go to Chuck E. Cheese. I pretty much live at Chuck E. Cheese. I know all the workers there. I know how to beat all the games now, so I can get them more tokens. That is one thing that my little girls really like to do, and that's what I do with them. So that is my, I wouldn't call it guilty pleasure because I don't love it, but you'll see me there. In terms of me personally, what I do, kind of embarrassing, but I am a car singer. So if you ever pull up on the side of the road next to me at a stoplight or a stop sign, you might get a show, because that's one thing that I like to do. I'm a car singer, and I like to break it down. That's my form of relaxation.
Absolutely. I love it. That was an amazing time again spent with you today, Matt. And if anyone needs your professional help and is looking for the Rittgers Rittgers and Nakajima, how can they reach you? Do you have a website, social media resources?
Yes. My website is Rittgers, RITTGERS.com. And you can also find us on social media. We are on LinkedIn. Me personally, it's Matt, M-A-T-T, Nakajima, Nakajima. And we're also on Instagram and Facebook. We don't do any online marketing, but you can go to the website, or you can check us out on social media.
I love it. That again was attorney Matt Nakajima with Rittgers and Nakajima based in Ohio. I want to thank you all for listening and watching our story today. For more tips and tricks on legal funding and personal injury related topics, follow me, download, like, and subscribe to It's Time for More Injury Funding podcast on several podcast platforms, including but not limited to Spotify, Amazon Music, Apple Podcasts, iHeart, and others worldwide. And follow More Injury Funding on LinkedIn, Instagram, Facebook, Twitter, TikTok, Pinterest, YouTube, Google Business Profile, and my website at moreinjuryfunding.com. I can't wait to see you and hear from you again soon. Until then, be well. Thank you so much.
Thanks, Laura. Bye-bye.
Bye.